Justin Trudeau finally got spanked the way he deserves, and probably not in the way he likes. Viva Frei, former Montreal litigator turned current Florida rumbler, and this is Winnie the Westie, basking in the sunlight and the sounds and the smells. What do you say? All right, well, you go sit down over here for now. Some good news finally coming out of Canada and the world. The Canadian Federal Court finally issued a ruling on a judicial contestation of Justin Trudeau's invocation of the Emergencies Act, and they came to the conclusion that no, it was not reasonable to invoke the Emergencies Act to suppress the most peaceful protest Canada has ever seen. But before we get into that white pill story, there was actually another white pill story of the day from yesterday. As at the time of shooting this vlog, Robert Barnes is representing an Amish dairy farmer named Reuben King, who was arrested and convicted, not under the representation of Robert Barnes, convicted of selling firearms without the requisite firearms license, and he was facing up to 5 years in prison. And under Robert Barnes' representation, he was let off on probation, no jail time. Amazing news for him and his family, as Robert Barnes put out on Twitter yesterday. So this week might be the week of white pill stories, and I think one of the biggest white pills coming out of Canada, a federal court declared Justin Trudeau's invocation of the Emergencies Act to be unlawful, unwarranted, unnecessary under the circumstances. And I'm going to break down that decision because it's 190 pages. So on its face, it's prohibitively long to read, but then you look at it and something like 63 pages are exhibits. The first 20 pages are summarizing facts that we are all pretty much already aware of. And then you have like 20 to 30 pages dealing with procedural issues such as mootness, which I am going to focus on for the purpose of this vlog. So ultimately, there might have been like, 60 pages, which is still a lot to read, a lot to digest. And I'm going to break it down and flash some of the highlights, which I think are the most relevant highlights. Now, to briefly summarize the 20 pages of fact pattern in this case, if you've been around the channel for long enough, you already know it. If you are watching my documentation of the protest, you know it. But just to summarize it very briefly, in early 2022, towards the end of January, early February, a convoy, the so-called convoy, truckers from across Canada, descended onto Ottawa. They drove to Ottawa from all corners of Canada to protest the COVID measures, the vaccine mandates, the government overreach, and what was supposed to be a weekend protest turned into 3 weeks of the most beautiful, peaceful protest you have ever seen in your life. Justin Trudeau never once stepped foot onto the street to talk to the protesters, and he's proud of his decision to do so.
I have attended protests and rallies in the past when I agreed with the goals, when I supported the people expressing their concerns and their issues. Black Lives Matter is an excellent example of that. But I have also chosen to not go anywhere near protests that have expressed hateful rhetoric, violence towards fellow citizens, and a disrespect not just of science, but of the frontline health workers and, quite frankly, the 90% of truckers who have been doing the right thing to keep Canadians safe, to put food on our tables. Canadians know where I stand. This is a moment for responsible leaders to think carefully about where they stand and who they stand with.
So after weeks of doing nothing, all out of ideas, he had the great idea of invoking the Emergencies Act. Now, the Emergencies Act is like the nuclear bomb of Canadian legislation. It replaced the War Measures Act. It has only been invoked 3 times in Canadian history, from what I understand. Once during wartime, another time by Justin Trudeau's father when he was battling the FLQ crisis, le Front Libération de Québec, which was an actual terrorist organization in the late 70s, actually planting pipe bombs in mailboxes, actually kidnapping politicians and killing one of them. A politician by the name of Pierre Laporte was actually kidnapped and killed, but there were actual killings occurring when Justin Trudeau's daddy invoked the Emergencies Act. But according to many, even when Pierre Elliott Trudeau invoked the Emergencies Act, he still went too far with it. And then the satanic spawn of an apple that is Justin Trudeau, clearly not falling too far from the apple tree of his father, he invokes the Emergencies Act in order to violently suppress the most peaceful, beautiful protest Canada and the world has ever seen. Under the legislation of the Emergencies Act, the government is required to convene a commission. It was known as the Rouleau Commission, to investigate the circumstances surrounding the invocation of the Emergencies Act. We all watched that for the weeks that hearing went on, and Commissioner Rouleau came to the conclusion that, yeah, Justin Trudeau was justified in invoking the Emergencies Act. Now, I bring that up because it's going to be a relevant distinction that the judge of this federal court is going to have to make, in that how did Commissioner Rouleau come to a different finding than this federal court judge? The judge does it. He does it impeccably well, and I'm going to highlight that when we go through the decision. So the partisan hack, Monsieur Rouleau, who is the Commissioner commissioner comes to the conclusion that Justin Trudeau was justified in invoking the Emergencies Act, but he might have gone a little too far in ordering the cancellation of insurance policies on the trucks, though he didn't go too far in freezing of the bank accounts because it proved to be an effective tactic.
No shit, Sherlock.
Violence, whether it's political violence, economic violence, or actual physical violence, we saw all three when Justin Trudeau violently suppressed that protest. No crap, it's a great way of suppressing protests, getting away. It's very effective at quelling dissent. So the partisan political hack that was Commissioner Rouleau came to the conclusion that Justin Trudeau was justified in invoking the Emergencies Act, and thus ended the political aspect of the investigation, but not the judicial one, because plaintiffs filed a federal claim alleging various violations of constitutional rights, and that the invocation of the act was not lawfully required, lawfully justified, and they took this battle to the federal courts to be distinguished from the political process that was the commission. And this is the court ruling in that court challenge, and this judge, God bless his soul, Richard Mosley, finally someone with some political courage to stand up to the political forces that be in Canada, came to the conclusion that no, it was not warranted, it was not necessary, and it was unlawful. Now, when I say that a lot of this decision was focused on procedural issues, as you can imagine, as one would anticipate, the government challenged the standing of the petitioners to even file the claim in the first place, alleging that some of the petitioners didn't have standing. I'm not going to get into it for too long, just to say that of the 4 petitioners that were represented by the Justice Center for Constitutional Freedoms, and by the way, I just interviewed John Carpe yesterday, as at the time of shooting this vlog, so go check out that interview. Of the 4 petitioners represented by the Justice Center for Constitutional Freedoms, 2 were denied standing, and 2 were recognized to have standing, because yeah, when the government unilaterally freezes your bank accounts with no due process, no court order, yeah, you have standing to challenge the government as relates to the Emergencies Act invocation that allowed such an egregious injustice. And now, since at least some of the petitioners had standing, we can get to the substance of the issue, or so you would think. First, we have to get through the issue of mootness, because as you can imagine, the government goes from denying, alleging that the plaintiffs don't have standing to get out of the substance, to alleging that the issue is now moot to avoid a decision on the substance. And mootness, for those of you who don't know, means that there is no issue anymore, because as the government argued, well, we rescinded the invocation of the Emergencies Act. Oh, I forgot to tell you that earlier. The Trudeau government invoked the Emergencies Act, but it's a 2-step process, so it has to go through the House of Commons, who have to vote on it, and then it has to get ratified by the Senate. And it never got ratified by the Senate, and by all accounts, it was not going to get ratified by the Senate, so it would have been a huge embarrassment on Justin Trudeau to have invoked the Emergencies Act, only for the Canadian Senate to say, no, we are not ratifying this. So what does the scoundrel of a political criminal do? He rescinded the invocation of the Emergencies Act barely a few days after having invoked it. Trudeau claimed the objectives have been achieved and that we don't even need the Senate to vote on it, and in so doing, he avoided the absolute political humiliation of potentially having the Senate not approve the invocation of the Emergencies Act. And by all accounts, the reason why the Senate was not going to approve it, and the reason why Trudeau was taking so much political flack for it, allegedly, from what I have been told by pretty reliable people, Justin Trudeau was getting calls from the banks saying, what the hell are you doing? We are getting runs on money in the bank, because when you froze people's bank accounts, other people no longer had faith in the financial institutions, and they were coming in to withdraw cash en masse, and the banks didn't have it, and they were calling Trudeau saying, what the hell are you doing? Stop doing this. But that is just a theory. The fact is that Justin Trudeau rescinded the invocation of the Emergencies Act before the Senate could ratify or strike down the invocation of it, and then the government actually has the audacity to argue mootness, in that they rescinded the invocation of the Emergencies Act, so nobody has anything to complain about. There is no controversy. It's moot. Court, please move on. Test for mootness, paragraph 124. A matter is moot when there is no longer a live issue between the parties and an order will have no practical effect. The respondent brought its motion to strike the 4 applications for judicial review on the basis that all the applications are moot, since they seek remedies in respect of legislative instruments that are no longer in effect, as the public order emergency ended and the proclamation, regulations, and economic order were revoked on February 23, 2022. Accordingly, the respondent argues there is no live controversy between the parties and nothing concrete or tangible for the court to opine on that will impact the rights and interests of the parties. Bullshit. I hate to swear, but my goodness, this year is going to be the year of swearing bullshit. Now, it's not bullshit that the issue might be moot, technically speaking, because the orders are no longer in effect. And in fact, all but one of the parties agreed that technically speaking, the issue is moot, but not moot to the point of irrelevance for the court to adjudicate upon. Oh my goodness, thank goodness this judge got it right. Paragraph 126, the court may also decline to exercise its jurisdiction to hear moot matters when the requesting party... Oh no, forget that one. Paragraph 127, in these proceedings, all of the applicants except for Nagel CFN conceded that there was no longer a live controversy between the parties as a result of the revoking proclamation and that the matter is now moot. They all contend that should the court find that the matter is moot, it should nonetheless exercise its discretion to hear the applications. The court then goes on with a very thorough and insightful analysis as to the exceptions to mootness. Some of the exceptions involve recurrence, whether or not it's likely to recur in the future and therefore be useful to adjudicate upon now, even though the issue has technically become moot. And another one is clean hands, which minorly applies in the case of this particular file, but we're not going to get to it. The major one is it in the public interest for the court to nonetheless adjudicate on this matter, despite what all but one of the parties conceded was in fact a moot issue. Paragraph 157, I am satisfied that the legislative history of the act weighs heavily in favor of the exercise of the court's discretion to hear the applications. Conclusion on mootness, paragraph 158, taking the public and national importance of the subject matter into account, which is not disputed by the respondent, and my conclusions on the factors of judicial economy and respect for the legislative process, and subject to my remarks below about standing, I am satisfied that the applications should be heard notwithstanding their mootness. So we have gotten past the procedural matter of standing, we have gotten past the procedural matter of mootness, and then we get into the substance of it, and the judge comes to the right conclusion whether or not a court of appeal is going to overturn this, because I could steelman the arguments that will necessarily be made in appeal, and Christia Freeland already took to the interwebs to announce that they will be appealing this because they're going to fight to our last dollar to prove that they were not wrong.
So we are aware of the court decision. We have discussed it with the Prime Minister, with cabinet colleagues, with senior federal government officials and experts. We respect very much Canada's independent judiciary. However, we do not agree with this decision, and respectfully, we will be appealing it. I would just like to take a moment to remind Canadians of how serious the situation was in our country when we took that decision. The public safety of Canadians was under threat. Our national security, which includes our national economic security, was under threat. It was a hard decision to take. We took it very seriously after a lot of hard work, after a lot of careful deliberation. We were convinced at the time, I was convinced at the time, it was the right thing to do. It was the necessary thing to do. I remain, and we remain, convinced of that. And I'll now turn it over to my colleague, the Minister of Justice, and then we'll hear from my colleague, the Minister of Public Safety.
On the substance of the contestation of the invocation of the Emergencies Act, and my goodness, is that a political tongue twister? Paragraph 294, while these events are all concerning, the record does not support a conclusion that the convoy had created a critical, urgent, and temporary situation that was national in scope and could not effectively be dealt with under any other law of Canada. The situation at Coutts was dealt with by the RCMP employing provisions of the Criminal Code. The Sûreté du Québec dealt with the protests in that province, and the Premier expressed his opposition to the Emergencies Act being deployed there. Except for Ottawa, the record does not indicate that the police of local jurisdiction were unable to deal with the protests. Not to toot my own horn, but I'm going to toot my own horn a little bit here. I can't believe I just came up with that joke for the first time. That is exactly what I was saying from day one of the invocation of the Emergencies Act. There was literally nothing that was going on that could not be resolved with existing legislation. The blockade at the Windsor border was resolved with a court injunction. All of the criminal charges that the protesters are facing, abusive as they may be, are existing laws under the existing criminal code. There was absolutely no need to invoke the Emergencies Act because it was already the existing legislation, existing remedies to end the protest with without invoking the Emergencies Act. Oh yeah, and a protest occupying at best 4 or 5 blocks of downtown Ottawa is not something that threatens the national security, the national infrastructure of Canada as a country. It's a pretty damn big country. 4 blocks in downtown Ottawa are not a national security issue. Now, before we get to the conclusion, and I'm going to read pretty much all of the conclusions so that no one accuses me of omitting prejudicial statements that the judge made as relates to the convoy, how did the judge get around Commissioner Rouleau's findings so as to come to basically the opposite findings in a court of law? Paragraph 144. I agree with the applicants that neither the public inquiry nor the special joint committee of the House of Commons and the Senate required by the Act to examine the declaration of emergency are substitutes for judicial review. Without dismissing in any way the importance of those procedures, their roles are not to adjudicate upon the legality and constitutionality of the measures adopted under the Act. Rather, their roles are to consider the events which took place and to make recommendations that, without legislative or other action, have no legal effect. While they are both important accountability mechanisms, they are legally and practically distinct from the court's adjudicative function. The present proceedings are thus not duplicative of the work done by the POEC or that being undertaken in the parliamentary process, contrary to the respondent's submission. The judge also goes on to make another important point by stating that the federal court's decision is susceptible of further review by the Court of Appeal by the Supreme Court of Canada, whereas Commissioner Rouleau's findings in the POEC, which was the Public Order Emergency Commission, is not susceptible of any judicial overview. And now, the conclusion. Paragraph 370. At the outset of these proceedings, while I had not reached a decision on any of the 4 applications, I was leaning to the view that the decision to invoke the EA was reasonable. I considered the events that occurred in Ottawa and other locations in January and February 2022 went beyond legitimate protest and reflected an unacceptable breakdown of public order. I had and continue to have considerable sympathy for those in government who were confronted with this situation. Had I been at their tables at that time, I may have agreed that it was necessary to invoke the Act. And I acknowledge that in conducting judicial review of that decision, I am revisiting that time with the benefit of hindsight and a more extensive record of the facts and law than that which was before the GIC, which means the Governor in Council. Paragraph 371. My preliminary view of the reasonableness of the decision may have prevailed following the hearing due to excellent advocacy on the part of Counsel for the Attorney General of Canada, had I not taken the time to carefully deliberate about the evidence and submissions, particularly those of the CCLA and CCF. Their participation in these proceedings has demonstrated again the value of public interest litigants, especially in presenting informed legal argument. This case may not have turned out the way it has without their involvement, as the private interest litigants were not as capable of marshalling the evidence and argument in support of their applications. Paragraph 372. I have concluded that the decision to issue the proclamation does not bear the hallmarks of reasonableness, justification, transparency, and intelligibility, and was not justified in relation to the relevant factual and legal constraints that were required to be taken into consideration. In my view, there can be only one reasonable interpretation of EA sections 3 and 17 and paragraph 2C of the CSIS Act, and the applicants have established that the legal constraints of the discretion of the GIC to declare public emergency order were not satisfied.
Yes! Yes! Oh, yeah! Can you feel that, buddy? Huh? 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 I have exorcised the demons. This house is clear.
And there you have it, the judicial smackdown of the Trudeau regime, but they're going to appeal it, and my concern is that the judge did leave open a number of doors for a successful appeal. You get 3 judges who are not as politically courageous as Judge Mosley, and they'll overturn this. The higher courts have more discretion to disagree with the lower courts as relates to matters of law, and that seems to be what is at issue here, not necessarily matters of fact. So I am concerned for appeal, knowing how the process works, but at the very least, for the time being, something of a white pill, Justin Trudeau getting a bit of a judicial smackdown that he deserves, and now you have a better understanding than 99% of the people out there. And if you like what I do, be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below because it feeds the algorithm. Follow me on Rumble, Viva Frei, Twitter, the Viva Frei, on vivabarneslaw.locals.com, where everyone in our community is above average. And I just got a call, I think it's a press call, to talk about this very issue, so I'm gonna go take it. Get outside, get exercise, eat healthy, talk to people in real life, and now you know your vlog. Peace out, peeps. Booyah!
The emergency was that we were living under a tyrannical regime for the last 2 to 3 years, imposing unscientific, constitutionally abusive vaccine passport mandates, all this crap on the truckers, who are the ones, feeding the country literally. And so they descended onto Ottawa from all corners of Canada, Nova Scotia on the east, Vancouver on the west. They drove to Ottawa, and it was a 3-week massive, peaceful, beautiful protest. Justin Trudeau, that filthy coward that he is, didn't take 1 second to step out onto the street to talk to the protesters. He justified it that you don't negotiate. I don't attend protests where I don't agree with the subject of the protest. That's because you're an idiot, and that's not what leading a country is about. You don't only represent the people who voted for you. You don't only listen to the people who voted for you. So he says, I'm not even going to cross the street to talk to these people. I'm going to come down with an iron fist, call in. Alex, I mean, I was there. They were detonating concussive grenades on the day they violently broke this up. They called in, I mean, you won't know what all these names mean. RCMP, the Royal Canadian Mounted Police. OPP, the Ontario Provincial Police. Sûreté de Québec, which is the police from Quebec. They had the York Police. They called in all of the police, but Justin Trudeau says, don't worry, we're not calling in the military. No, you're just calling in a highly militarized police force. They had snipers on building tops.
Sure, so what do you make of her defending this in that conference we just played yesterday and literally saying there was such a threat, she says, by the people? I mean, this is like ridiculous.
It's ridiculous, but you notice also she discreetly threw in this unknown concept of economic threat. That's not a criteria for invoking the Emergencies Act. These people are scoundrels of the highest order.
Plus, they were protesting the blockade, the siege of the lockdowns, which was the economic threat we know.
Well, that's the ultimate hypocrisy irony in all of this. They say that 3 weeks of occupying downtown Ottawa caused economic interruptions. They had shut down the country for 2 years. And by the way, they shut down Ottawa for months after the protest was over, setting up their blockades, crippling the infrastructure there. They are scoundrels of the highest order. There's no other way to say it. Chrystia Freeland is a loathsome human being. And it's arguable who is more detestable between her and Justin Trudeau.
Sure, so where does this go now? Because obviously they admitted it was a beta test for the world, the grabbing of the bank accounts, they admitted that, it was celebrated. It's now backfired on them. What comes next for Trudeau and the other WEF stooges?
And just so everybody knows also, Chrystia Freeland is on the board of trustees of the WEF. She's I forget what her position is in Canada, but she's like the second most powerful person to Trudeau. She's on the board of trustees of the WEF. You tell me how that's not a conflict of interest.